In addition to having a financial power of attorney, the other that you're going to have is a medical power of attorney, sometimes in other states referred to as a healthcare power of attorney or even a healthcare proxy. All of these are the same document. And the basic premise is that if I reach a point in my life where I am unable to make my own decisions, I have become incapacitated, then I need someone who can step in, work with my doctors, manage my healthcare, authorize medical procedures, and the like. In somewhat stark comparison to the financial power of attorney, the medical power of attorney that we're going to provide you is quite a bit shorter. The document, instead of trying to identify every single decision that needs to be made and how it's to be made, the medical power of attorney is more an organized set of guidelines. How do we want someone to go about the process of caring for us? To that end, what I strongly encourage people to do as they read this document, we all have different expectations. We all have different preferences. We all have different values. So, as we think about the future, to whatever extent we might find ourselves unable to provide our own decisions and care, we might want to put some effort into telling people how we want that done. I will show you all of the different sections that are in this document, but to the extent there are any pieces that are not in here, you are more than welcome to add them. Sometimes we'll add additional guidelines into this actual power of attorney. Other times we'll actually just prepare a running set of guidelines that a client will have, and then we'll attach that to the back, just to notify the agent under power of attorney how we want everything to be handled. Some common examples for things you may consider beyond what is in this document. Number one, if you happen to have any religious preferences. I have a number of clients that are Catholic, as an example. And much of the Catholic doctrine, there are restrictions in terms of how decisions are made for us, especially when it comes to certain end of life decisions such as life support. Beyond religious preferences, we might just have personal preferences. I have many clients who unfortunately had to care for parents with dementia, as an example. And they might come to me and say, should I end up being diagnosed with dementia, I want to make sure that there's A, B, C through Z done for me, because I wish I would have known that having to have taken care of my own parents. So in the medical power of attorney, if there is something that comes up for you above and beyond what I'm going to show you here, I want you to make note of that in some capacity. And then we can work with you either in developing the language for the actual power of attorney, or you writing up a set of guidelines that we then attach to the back. At the outset of the document, just like with the first power of attorney, who is going to make decisions for me first on this first line, and then who is going to make any decisions as a backup if they cannot. So just make sure that we know if the people are correct, if you want to change anyone, or if we need to change any names. Section 1.02, the power of attorney does have to end at some point, and this is simply identifying it ends if I happen to revoke the power of attorney, which you're capable of doing, or otherwise it's going to end when we pass away. Section 1.03, if you are married, please understand that there is just always a possibility you may not always be married. So you're likely to see a provision in your power of attorney that just says, if at any point, spouse, we don't stay married, then you are going to be removed from my document and it's going to drop down to the next person. The language is somewhat harsh, I will be honest, but it has to be that way because of how this particular process plays out. And then 104, when someone is serving for me as power of attorney, they receive what we call a general grant of authority. It is 2 sentences, and it's providing you can make any decisions necessary for my care, my doctors, my living environment, etc. And then finally, 105, effect on legal capacity. We need people to be able to make decisions for us in an emergency. We can't necessarily go through all of the steps that you saw in the financial power of attorney, where someone needs to actually document and prove that I'm incapacitated. So 105 is saying that formal process, it's not required here. My power of attorney, if needed, can make decisions for me. Please understand that when you're working with medical providers, you're going to be with them. They will be able to make the determinations on the spot if you can or cannot make your own decisions. And then that will inform them if they're going to be asking your power of attorney to make them for you. Now, the bulk of this document is going to be in Article 2. This is going to be guidelines and some very specific powers that we're giving a person who is stepping into our shoes. 201. What should a person be considering before they actually make a decision? An example would be if I tell you my wishes, you should try to follow my wishes first before you then go on to do something else. In 202, by default, a person who's serving as our power of attorney, they're going to be able to arrange every level of care that we may require. Home health care, long-term care, palliative care, hospice care, etc. 203, most people, when we're thinking about that situation, most people are going to say, I would like to continue being in my house. I would like to be in my home environment for as long as I can be. So keep me there. Don't move me to a facility unless it's absolutely required. In 204, when a person is serving for us, they're going to have access to doctors, access to records, access to facilities. Later in this document, in Article 3, there's going to be a HIPAA authorization, making sure that they have the legal backing to do that. In 205, when a person is serving for us, they're going to have management and control over all of our medical providers, everything from a dentist to a brain surgeon. In 206, this is a bit of a quality of life clause. Regardless of my circumstances, even if I have been taken off of life support, I don't want to be miserable. So, power of attorney, make sure that I'm comfortable, manage my pain, etc. They're going to do this for you, but we always like to say it just for the sake of saying it. In 207, this is a legal provision. There is a level of, let's say, care, a specific situation that we don't want our power of attorney just being able to decide for us. And that falls under the umbrella of psychiatric care. So the principal issue here is I don't want somebody being able to decide for me that I am a danger to myself or to other people. I don't want somebody unilaterally having the power to put me into an institution. This is such a rare issue, but it does happen, and I've actually had it happen in my career. 207 is outlining a process. To the extent somebody serving for us believes that there is a need for psychiatric care, they cannot decide that on their own. We now have to start bringing in qualified third parties, including psychiatrists, medical, physician level mental health providers. Ultimately, this can lead into a particular type of probate action that's called certification. And that's where, at the end of the day, a judge would have to make a decision that we are a danger and we would have to be institutionalized or medicated against our wills. It is incredibly rare that this issue comes up, but we do want to be clear in our power of attorney that our agent cannot just do this on our behalf. In 208, a person that's serving for us, they become us. So again, they can communicate for us, they can make decisions for us, and they can sign documents for us. So 208 is just making very clear my power of attorney as needed can sign documentation, including any legal paperwork necessary to facilitate my care. 209, one of the documents that we use in estate planning is the living will. It is a document that provides when I reach the end of my life, here are my instructions, here are my processes for removing me from life support. Now, in a separate video, I'm going to go through that document, but the purpose of 209 is simply to identify that I have a living will. I have already made these decisions, and I don't want you having to make them for me. So take this document and use this document. And then finally, 210, Some states have this as a separate document. In Colorado, we just consolidate everything into one to make it simple. When I ultimately pass away, I need somebody who can do something as basic as signing the paperwork to move me from a hospital, let's say, to a mortuary. So 210, this is providing your medical power of attorney with the ability to sign that paperwork. In Article 3, there are just some miscellaneous sections. In 301, this is a HIPAA release, making sure that when somebody is serving as our power of attorney, they have access as needed for all medical information. 3.02, the purpose of doing estate planning, again, is that we don't want to go into probate. Your medical power of attorney avoids a particular type of probate case called guardianship. So this is providing, should somebody try to go and become appointed as a guardian, I already have this power of attorney, so the person that's listed in it, they are then the person to serve as my guardian. And then section 3.03, when your power of attorney is acting for you, they're going to be interacting with a lot of providers and hospitals and all of those different things. So this is providing essentially a bit of that relationship between the agent who's acting for you and those third parties. As an example, your power of attorney can sign indemnification documents to make sure that there's no lawsuits that can come up. So 303, it's just a legal provision, but it's essentially defining some of that relationship here. And then in 304, so as with the financial power of attorney, I unfortunately in my career have come across situations where providers and third parties just flatly refused to honor the power of attorney. It is very frustrating, it is very problematic, and it's unnecessary, but we need to be able to do something about that. And so 304 is providing your person, your agent, as needed with the power to initiate any legal proceedings, to force a third party to accept this power of attorney and use it. And that includes asking for any sanctions and damages that result from the delays and the costs of having to go through this. At the end here, there are some sections that I provide in the financial power of attorney that I highlighted. Those are duplicated here, but just for reference. 305, sorry, this is a new one that's in here. The person who makes decisions for me, they're not liable. If someone makes a decision for me to receive a surgery and I die during that surgery, my family can't come and sue the power of attorney because that was not their fault. 306, when someone steps into our shoes, if they happen to put out money from their own pocket, then they're obviously entitled to be reimbursed for those costs once we get access to the money. 307, when we provide our documents, we're going to provide you with an original signed version as well as a digital copy. We're typically going to share that through that MyCase platform. So section 307 is simply providing a copy of this document is just as effective as that original that I have. Section 3.08, when we have any estate plan documents, as a reminder, they work everywhere. So your document crosses state lines just in case you are on a vacation, or even if you happen to move and you're living in another state and there's an accident. And then 3.09, as a reminder, your documents at any time after you sign them, you can change them or you can completely get rid of them. As long as you are still here and as long as you are capable of making those decisions. And then 3.10, very simply, if you have any prior medical powers of attorney in place, this is going to revoke those in favor of this new version. Article 4 has some final definitions, and that's the end of it. This is a much easier document to read, but this is one document where we may have more thoughts, more preferences above and beyond what's on the pages themselves. So I will encourage you, as you have any of those notes, again, you can incorporate them into this document, or you can prepare something on the side, provide that to us, and we'll help you incorporate it into your document once finalized. The remaining medical documents I'm going to do as separate videos from this, so please feel free to click to those for more information.